The question is that the motion be agreed to.
Mr Speaker.
The Honourable Leanne Dazelle.
Mr Speaker, the Labour Party will be supporting the first reading of the Trans-Tasman Court Proceedings and Regulatory Enforcement Bill, the Trans-Tasman Proceedings Bill, rather. We have, obviously I've been involved in this for quite some time. I was originally involved as the Associate Minister of Justice in 2003, instrumental in establishing the Trans-Tasman Working Group on Court Proceedings and Regulatory Enforcement. So it was certainly very satisfying to be able to sign the agreement on behalf of the New Zealand Government back in 2008. And I think it was a very good occasion. I actually really enjoyed it, and I recall Justice French hosting the occasion at the Christchurch High Court. It's the only time I've actually sat on the bench, and I have to say the view's kind of good from up there, but I wouldn't really. It's probably a happy memory rather than something that I would be ambitious to achieve in a future legal career. The preamble to the treaty is actually worth recording, and I'm not going to read it into the record, but just to summarise its main features. First of all, it acknowledges our long-standing friendship and close historic political and economic relationship, and of course the CER agreement itself. And I think it is worthy of noting for the record that it's this weekend that is it this weekend? Yeah, it will be this weekend when we celebrate, I think it will be the 27th anniversary of the signing of CER, 28th of August 1993. So it's actually quite a substantial event that is coming up. And I'm aware of this date because when I signed the treaty itself on behalf of New Zealand, we were in fact in the 25th anniversary year of CER, and we're 2 years down the track. So I think that it's quite significant that we are very close to the actual date of the anniversary of the signing of CER back in 1993. The second thing that the preamble does is that it acknowledges each other's confidence in the other's judicial and regulatory institutions. And I think that's quite a powerful expression, because what it does do is it does enable both jurisdictions to essentially give up something in order to know that they will be in a good, strong position regardless of which side of the Tasman the particular action is being mounted. The third thing is that it affirms the shared commitment to appropriate and effective resolution of Trans-Tasman civil disputes and increased regulatory cooperation. Of course, that's a major platform of the SEM agenda, something I had much involvement in myself as Minister of Commerce in the previous government. And then finally, it agrees to build on the existing cooperative regime regulating the taking of evidence and associated court procedures to further streamline aspects of civil court proceedings and regulatory enforcement, and to reduce unnecessary procedural and regulatory business to the conduct of litigation. And then there are a long list of things that the agreement does, but in essence it simplifies the Trans-Tasman service of court proceedings and enforcement of judgments, it expands the range of enforceable judgments, and it improves regulatory enforcement of civil pecuniary penalties and certain criminal regulatory fines. I want to congratulate the government for retaining the regulatory impact statement within the document itself. I know that the government has made a decision to take the regulatory impact statements out of the printed bills and to only have them available on the Treasury website. I state again for the record, I think this is a mistake. They are incredibly useful for MPs in the House to be able to pick up the bill off the table of the House and to see the process that the government has gone through in a quality regulatory impact analysis way. And I really do reinforce how worthwhile they are. And this bill is a very good case in point. This has got an excellent regulatory impact statement within it. And the reason that I say that is that it has actually done exactly what a regulatory impact statement should do. It states the public policy objectives of the legislation up front. So we have a very clear statement of what the legislation is designed to achieve. And so we have it here that the public policy objective for Trans-Tasman court proceedings is to achieve closer integration between the New Zealand and Australian civil justice systems in order to make resolution of civil disputes less costly and more efficient, and make any remedies more effective, and support the success of the trade relationship between New Zealand and Australia. So within those three short statements, we have encapsulated the public policy objective of the legislation. Then it goes on to state a further objective, which is to improve the enforcement of various regulatory regimes in which both countries have a strong mutual interest. It talks about reducing incentives for people to move themselves or their assets to the other country to put themselves beyond reach of a regulatory regime and to avoid enforcement gaps that would otherwise exist. We all know examples of people who have gone to Australia in order to avoid obligations that they have in New Zealand. This obviously is a public policy statement of some merit and something that all sides of the House can support. The next element of a regulatory impact statement is to set out all of the options. And this bill does. It actually sets out 4 options, not just 1 or 2. It starts with the status quo, and in doing that, it actually identifies what the flaws with the current arrangements are. Secondly, it talks about strengthening the existing legislation, which are the Reciprocal Enforcement of Judgments Act 1934 and the Foreign Judgments Act 1991, which is the Australian counterpart. But as that option spells out, that's only a partial solution. So it actually wouldn't be in the interests of good governance to pick up that as an option. The third option is legislation based on the Brussels model, which is about easing the enforcement of civil judgments between EU member states, and it talks about mirror legislation being required in Australia. Again, that has some limitations and has been identified in this particular option that's spelt out in the bill here, that where more than one court has jurisdiction, priority is decided by a first-to-file rule. Now, we know that the way that we're adopting between Australia and New Zealand is a give-way rule, and I think that that has considerable merit over and beyond the first-to-file rule, because we do know that there are limitations with that first-to-file rule from time to time. So the preferred option, which is option 4, set out in the regulatory impact statement, is this Trans-Tasman Proceedings Bill based on the agreement that I signed back in 2008 with the Honourable Robert McClelland, the Attorney General from Australia. So I think that this is an excellent example of why regulatory impact statements should be included within the framework of the actual bill that's tabled in the House. Now, I know that I could have gone to the website and I could have downloaded the regulatory impact statement if it hadn't have been printed in here, which is exactly what I've had to do for the next bill that we're going to be debating on the order paper, the Securities Trustees and Statutory Supervisors Bill, one of the most important bills in financial regulation that this House will deal with this year, and that bill does not have a regulatory impact statement in it. But I will certainly come back to that when we get to that bill. The Trans-Tasman's Proceedings Bill, on the other hand, has got an excellent summary of how the government came to the conclusion that this was good for New Zealand, it was good for Australia, but most importantly, it was good for the relationship between Australia and New Zealand. It reduces compliance costs for business, and I think that when all of those boxes have been ticked, then it has to be the step in the right direction. So the Labor Party will be supporting the first reading of the Trans-Tasman Proceedings Bill. I certainly commend it to the House. I'm really disappointed that I won't be on the select committee that considers it in detail, but I'm sure those that have that privilege and advantage will feel that they have done a worthy exercise on behalf of the House as a whole.
I call Simon.